Hi, thanks for joining. We're going to be continuing on with the criminal trial process, particularly looking at pleas, charge, and negotiate. There we go. Okay, first of all, starting off with pleas. If the charge is indictable, meaning a serious matter, the accused will not be required to enter a plea until such time as the prosecution has served a brief of evidence containing statements from prosecution witnesses and other documentary evidence such as drug analysis results on the accused. The accused is entitled to adequate time to consider this evidence and obtain legal advice before entering a plea. If they refuse to enter a plea, then it will be taken by the court to be a plea of not guilty. If a plea of not guilty is entered, the matter proceeds to a defended hearing. This will be in the local court for summary matters and some less serious indictable matters which may, on election, be heard in the local court. The severity of the offence will determine which court, being local, district or supreme, imposes the sentence. For serious indictable matters, a committal proceeding is held in the local court to establish guilt or innocence, but also to determine that there is a case to answer. And as has been discussed in previous videos, this is called a prima facie case. If a prima facie case is found to exist, then the accused is committed to stand trial at a later date in either the district or supreme courts, depending on the severity of the offence. So plea bargaining is often a controversial thing and is something that has been, romanticized in some ways by Hollywood and TV shows. What it is, essentially, the accused will admit to a lesser charge in order for higher charges against them to be withdrawn. This results in a faster and a far less costly procedure for cases for the prosecution and in turn the legal system. But you can see there are always fors and againsts. So fors, we've got, as has been touched on, very brief, decreases time, it's negotiation. Courts can take months, even years to get through trials. This dramatically reduces that time. It increases the rate of criminal convictions because to get let off or for the charges to be withdrawn, so higher level charges, they still have to admit to something lower. Convictions on a lesser charge is better than no charge at all, many people would argue. Now, against that is some crimes will go unpunished because they have been withdrawn. The accused may plead guilty to a lesser charge. Oops, spelling mistake there. Plead guilty to a lesser charge. Sorry, I got tongue-tied there. The accused may plead guilty to a lesser charge that they're actually innocent towards, so that way then the higher charge against them is withdrawn and they can get away with a bit of crime. It may lead to bullying of the accused and not giving the right to a fair trial. So you need to assess the effectiveness and balancing of rights. The shape has gone out of whack with my words there, but it is a great resource for assessing effectiveness and balancing rights, so addressing those themes and challenges in the syllabus. So you really should be familiar with charge negotiation. We've mentioned it only in passing in the past few videos. Following on from negotiations between both parties, being the prosecution and the defence, some cases the accused may agree to plead to a lesser charge. An assault occasioning actual bodily harm just becomes assault, or to the same charge but with the facts changed in some respect. So things are downgraded, and that's the key, is that they are coming down. So another example might be the accused being agreeing that they shoved but not punched the victim, and so by consent the reference to punch is removed from the facts, which the magistrate will consider on the sentencing. Alternatively, the accused may agree to some but not all charges, and that basis may be that the remaining charges will not be proceeded with, withdrawn. It's important to consider fully the ramifications of this process. How does it impact on the system? How does it impact upon the victim, the accused, and society in general, including the issue of resource efficiency? So, whilst it increases efficiency, is justice being served? Or is it some watered down version of justice? To get the full justice, do we need trials to go their full term? Some would say yes, but that would also decrease the efficiency and the resources given to the criminal justice system. All these things you need to consider.